So, what actually happens when strict political loyalty just completely collides with a politician's individual conscience? Well, today we're diving into a genuine constitutional thriller. We're looking at a landmark 2002 judgment from the Constitutional Court of South Africa that tackled this exact, very messy issue. It is an absolutely brilliant case study in democratic design, proportional representation, and, as you're going to see by the end of this explainer, a massive legal plot twist. Let's get into it.
Picture this scenario for a second. Imagine you were elected to a legislature, not because voters ticked your specific name on a ballot, but because they voted for your political party, right? Now, imagine a few years go by and your party decides to merge with another one, or maybe it splits, or it just fundamentally changes its platform, and suddenly you realize you don't agree with them anymore. Here is the million-dollar question. Can you switch teams, what's often called crossing the floor, without losing your job, or does that seat belong permanently to the party?
Section 1. A political trap, the birth and fracture of an alliance.
To really understand the high stakes here, we have to start with how three very distinct parties became completely entangled. Back in June 1999, the Democratic Party, the Federal Alliance, and the New National Party contested the national and provincial elections as completely separate entities. But then, literally just a month later, in July, they decided to join forces. They formed this new coalition called the Democratic Alliance, or the DA, and even contested the October 2000 local elections as this single, unified party. But fast forward to November 2001, and a massive political realignment takes place. The New National Party dramatically pulls out of the DA. This completely fractured the alliance and left local government representatives who actually wanted to leave the DA totally stranded.
You might be wondering, why were they stranded? Well, because of something called an anti-defection clause. These politicians were effectively trapped in their seats. You see, the South African transitional constitutional rules contained a very strict anti-defection mandate. Basically, if you ceased to be a member of the party that originally nominated you, you automatically lost your seat. Poof, gone. It was a rule specifically designed to keep politicians tied to the mandate of their party. But in the wake of the Democratic Alliance splitting, it meant that anyone who wanted to follow their personal conscience and change parties was going to find themselves out of a job.
Section 2. The floor-crossing legislation. Building an escape hatch.
Parliament obviously saw this crisis unfolding, and in June 2002, they took action. They passed a package of 4 distinct acts to lift this ban. For municipal politicians, they paired the First Amendment and Local Government Acts. And for the national and provincial reps, they rolled out the Second Amendment and Membership Acts. The ultimate goal here was to create a unified, legal pathway for politicians to switch their allegiances without instantly getting fired. But importantly, Parliament didn't just make it some wild free-for-all. They introduced some pretty strict rules to maintain political stability. I mean, politicians couldn't just defect on a random Tuesday, right? First off, they had to wait for a specific 15-day window period that only ever opened in the second or fourth year after an election. Secondly, for those standard window periods, a politician couldn't just leave all by themselves. At least 10% of the party's representatives had to agree to leave together. If and only if these specific conditions were met, they could switch parties and keep their seats. So it was a highly managed escape hatch.
Moving on to Section 3, the constitutional challenge, defending proportional representation.
Now, let's look at this clash impartially, because it's fascinating. On one side, you have the United Democratic Movement, or UDM. They argued that because voters vote for a party under proportional representation, defecting essentially steals the seat from the party and outright betrays the voter. Makes sense, right? But the court countered this. They argued that democracy doesn't strictly mandate anti-defection laws. Elected representatives actually need to have some freedom to change their minds. And, the court reasoned, if the voters are really angry about it, well, their ultimate remedy is to just punish those defectors at the ballot box during the next election.
To put this debate into perspective, the stakes were incredibly high. The UDM pointed out a very stark political reality at the time. The ruling party, the ANC, held a commanding 252 out of the 400 seats in the National Assembly. The UDM was terrified that allowing floor crossing in a young democracy would basically allow this massive majority party to offer inducements and unfairly swallow up smaller opposition groups, which would weaken multi-party democracy across the board.
Section 4. Democracy and party loyalty. The court's philosophical ruling.
So how did the highest court in the land actually balance this demand for loyalty against democratic freedom?
Well, the judges carefully acknowledged the tension. They totally agreed that parties are paramount under a list system, and a party that completely abandons its manifesto is probably going to lose the next election. But they drew a line in the sand. They firmly stated that an individual member absolutely must remain free to follow the dictates of personal conscience. They essentially ruled that a proportional representation system just does not automatically require a permanent constitutional ban on crossing the floor. If Parliament wants to allow it, they have the right to do so.
Now, back to that 10% threshold rule we mentioned earlier. The UDM argued this was completely unfair, and honestly, if you just think about the math for a second, you can kind of see why. If you belong to a tiny party with only 3 seats, just one single defector meets that 10% requirement. Super easy. But to defect from a massive party like the ANC with its 252 seats, you need to convince 25 other people to leave with you just to hit that 26-person requirement. It is mathematically way harder to defect from a large party. But the court? They ruled this threshold was completely rational. The goal was to prevent frivolous, single-person defections and ensure there was a genuine shift in public or party opinion. The fact that the math disadvantaged larger parties didn't make it unconstitutional in their eyes.
Finally, Section 5. The fatal flaw. A plot twist on a procedural technicality.
Okay, so the government had successfully defended the overall concept of floor crossing. They won the philosophical battle. But they were about to lose the war on a massive legal plot twist. You see, when the permanent constitution was adopted, the ban on floor crossing was actually tucked into the transitional arrangements, specifically Item 23A. The drafters knew they might want to change this rule later, so they built in a secret loophole with a ticking clock. Item 23A gave Parliament the special power to pass an ordinary act to amend the anti-defection rules, rather than dragging everyone through a full, heavy constitutional amendment. But there was a catch. They were only allowed to use this shortcut, quote, within a reasonable period after the new constitution took effect.
And this right here is the fatal flaw. The new constitution took effect in February 1997, but Parliament didn't pass this floor crossing legislation until June 2002. They waited 5 whole years. The Constitutional Court looked at this timeline and essentially said absolutely not. 5 years is way beyond a reasonable period for a transitional provision that was only meant to be active until the next election in 2004 anyway. Because Parliament dragged its feet, that special shortcut window had firmly shut.
So, let's look at the final scorecard. It reveals a really fascinating split decision. The First Amendment Act and Local Government Amendment Act actually survived, meaning local municipal politicians were officially cleared to cross the floor. Why? Because their rules were structured just slightly differently in the Constitution and weren't caught in that same reasonable period trap. The Second Amendment Act also technically survived, but the Vital Membership Act, the one that actually enabled the floor crossing for national and provincial politicians, was struck down entirely on that timing technicality. The government passed it too late, rendering the whole thing invalid.
It's an incredible conclusion that proves that in constitutional law, timing and procedure are often just as important as philosophy and rights. So I'm going to leave you to ponder this final question. If your representative changes their mind mid-term, whose seat is it really? Does it belong to the individual's conscience, or does it belong to the party that the voters backed? I really hope this explainer gave you a clear understanding of the delicate balance of political power, proportional representation, and the brilliant, sometimes crazy intricacies of constitutional law. Thanks for learning with me.